Hello, everyone, and welcome to the Aspen Author webinar series. Today's topic is teaching torts without committing them. Before we begin, I have a few housekeeping items to review. The audio for this webcast is through internet only. Please use a headset or earbuds or listen to this presentation through your laptop or mobile speakers. This is a one-way communication channel. You can hear us, but we can't hear you. So if you have any questions, please use the chat feature to the right of your screen. And now I will hand it over to Joanne to introduce today's presenter.
Thanks, Neil. Hey, everyone. Thank you so much for joining us today. I'm Joanne Butler, and I'm the managing editor for the Doctrinalist here at Aspen Publishing. I'm fortunate to be able to work with an amazing group of legal scholars to develop resources for first-year law students. It's my honor today to be able to introduce you to the author of the 10th edition of the Torts Process, Doug Kysar. Principally authored by James A. Henderson, the late Frank B. Ingersoll Professor of Law, the Torts Process has provided students with a clear and sophisticated treatment of the law of torts for over 50 years. Professor Kysar is the Joseph M. Field Class of 55 Professor of Law at Yale Law School, where he teaches torts, environmental law, climate change, and products liability. He served previously on the faculty at Cornell Law School, which is where he first started collaborating with Professor Henderson. Professor Kysar?
Thank you, Joanne. And thanks to Aspen for organizing this, and thanks to everyone who's chosen to join us here. I'm really excited to have this conversation with you. As Joanne mentioned, I am a co-author on Jim Henderson's casebook, The Torts Process, and I really want to take a moment here at the outset to honor Jim. He was a remarkable colleague and mentor to me. One of the things I admired most about him is that although he was extraordinarily accomplished and impactful as a scholar, he took as much pride in his role as an educator. I learned a great deal from him in our time collaborating together, and I felt his absence especially strongly as I planned for this conversation today about torts pedagogy. I know it would have been a richer and deeper conversation if Jim were still here to join it. What I want to talk to you today about is an all too familiar position that we find ourselves in as teachers today, which is namely the position wedged between a rock and a hard place. On the one hand, how do we ensure a learning environment that is welcoming and healthy and supportive of all of our students? And that is a challenge I know that many of us have top of mind and have increasingly been focusing on in the last few years. For me, it's something I've worried about for over 20 years of teaching torts now. The very first time I ever taught torts, I was a very, very green and inexperienced teacher, and I was a few weeks into the semester teaching a causation case. Some of you might know this case, Dillon versus Twin State Gas and Electric Company. And it's a case in which a young child falls off a railroad bridge and reaches to grab an electric wire that's strung alongside the bridge in an effort to stop his fall. The wire happens to have a current running through it, and it raises all sorts of interesting causation questions about what the electric company's causal responsibility is in relation to the child's death by electrocution. I called on a student Socratically, just randomly chose a student from the name chart, and the student burst into tears and ran from the room. And what I didn't realize is that I had called on a student who lost their best friend to electrocution when they were a child, and that the case, the student had been up all night kind of reliving that tragedy and fearing the memories that would be triggered and the ability to kind of concentrate and maintain composure during class. And then lo and behold, I had the great lack of luck to call on that very student. And that's a pretty eccentric case in a lot of ways, but it's emblematic of the kinds of landmines I think that are out there in our classrooms, and that exist largely because of the the nature of our subject, in which we're constantly working with injury and pain and suffering, and often working with those human injuries and human sufferings in contexts that are especially raw and especially sensitive, contexts involving sexual assault or racially motivated violence or hate speech or transphobic violence, and the list kind of goes on and on. So how do we create a learning environment in which we can grapple with those difficult and sensitive subjects in a way that's, to use the vernacular of our students these days, in a way that's safe for them, where the space feels secure so that they don't feel that they're going to be um, threatened or otherwise harmed by the nature of the conversations that are being had. So we have that dilemma on the one hand. On the other hand, we still need to maintain open and critical engagement with those same challenging and sensitive issues. So how do we ensure that pedagogically we're still fulfilling our responsibility to deeply and critically grapple with the materials and the full range of arguments that exist and are provoked by the materials we're dealing with, while still creating that healthy learning environment. That, for me, um, creates a special challenge in that I don't necessarily have each year a widely representative group of students um, that are representative of the political climate in the larger country. So this is from a recent torts class that I taught. And as you can see, the self-identified political outlook of the student body was overwhelmingly liberal or very liberal. A mere 15% identified as moderate, and one lonely person identified as very conservative. So how do I fulfill pedagogical responsibilities um, to, 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 to have our students grapple with the full range of legal and political arguments that are implicated in a given subject, knowing that I can't necessarily rely on the students themselves to bring that full range to the fore, at least not without them playing some form of devil's advocate that might well be very unsettling to them to play. Um, so that's one layer of challenge. And then here's another layer of challenge. I asked the students, that same group of students, how eager they were to learn with people who hold different viewpoints. And as you can see, fully half the class was either not eager or only very tepidly eager, at least according to their own accounts. And I don't think this surprises any of us. I mean, it's a fraught time in the country at large and also in our law schools. The level of trust and kind of reciprocity and mutual respect is down. It's down on Capitol Hill, it's down in our classrooms, it's down on airplanes, it's down everywhere. Civility is unfortunately in a recession at the moment. So how do we continue to live up to the kind of standards of pedagogical excellence that we all hold ourselves to in this changing environment? Well, that's kind of what I want to talk about today. And I'll just kind of shamelessly say that I think Jim's casebook is a good vehicle for navigating that challenge. And I promise not to make this too much of an infomercial. But Jim had a distinctive orientation to law and law teaching. He really wanted the book to be as student friendly as possible. He was very opposed to hiding the ball. He was opposed to kind of long numbered lists of esoteric questions. He was very opposed to kind of the professorial mind reading model of law teaching. He wanted to lower the stress and the tension associated with learning the law. And I believe that that kind of helps the students as they're grappling with sensitive material because they don't have the added layer of anxiety of trying to decipher mysteries about the casebook. The casebook tries to be as transparent and accessible as possible. Also, Jim was very influenced by Hart and Sachs, Lon Fuller, and the Legal Process School. And that's evident in his scholarship. It's also evident in the book because he very much focuses on situating substantive tort doctrine in a context that's very focused on process, on procedure, on adjudication, and that kind of dynamic process-based vision of how cases are resolved, I find can help the students stay focused in a way, like stay focused on the lawyerly aspects of challenging and sensitive material, um, you know, not to the exclusion of the moral and political values that are at stake, certainly, but in a way that kind of it focuses the mind on the lawyerly aspects in a way that can lower the stakes somewhat, at least hopefully. Also, Jim was very committed to a problem-based teaching approach, and so the book is filled with pretty richly described hypotheticals. And I find those are useful because when students are allowed to play a role as opposed to simply express their viewpoints or their values, I find they feel more comfortable trying out a range of arguments, a range of lines of reasoning, when it's clear to everyone in the room that they're being asked to play a particular role. Um, all that said, the book is now over 50 years old, which means that it's had to evolve significantly as the times have changed. And one of the reasons Jim brought me on board back in 2005 to start working on the book was that he wanted me to try to modernize it a little bit. Unfortunately, I'm now in the in the age bracket where I need my own modernization. But one of my goals with every edition is to pay very close attention to language and inclusivity to kind of update and diversify the source materials, the authors, the issues that are being treated in the book. And in that regard, I also want to acknowledge and thank Professor Jennifer Riggins from the University of Maine School of Law. As some of you probably know, Professor Riggins is a wonderful tort scholar and has done a lot of great work on race and gender and tort law, and has done a sort of public service for all of us torts teachers by sharing her materials and her thoughts and experiences through blogs and other methods. And she was very generous in helping me to improve the book. So for the rest of my time before we go to questions, I want to just cover three different examples of torts pedagogy that attempted to navigate this challenge of being welcoming and inclusive while also fostering open and critical engagement. And in some of the examples, I think I did a pretty good job as a teacher. In others, not so much. But if openness and self-reflection is part of what we want to promote in our students, then we should model it ourselves. So I'm going to try to be open and self-reflective about my ups and downs as a teacher. And I'll start with a very good example, I think. So this is a problem in the book, and it's had a long history, and it's had a challenging history, I would say, particularly in recent years. So the book, the problem is it's a battery case. And the question is whether the defendant can adequately assert self-defense as a privilege. The hypo involves a small grocery store owner who is sort of surprised by a customer entering during a rainstorm, turning as they enter the store, holding what might look like to the store owner as a gun, but in fact was an umbrella. Um, and the grocery store owner then shooting the customer in purported self-defense. Now, the problem has a number of issues of fact that are baked into it that all go to the question of whether the defendant's perception of a threat was reasonable. And they're contested issues of fact like, did the customer enter just before closing time or just after closing time? as they entered, did they have their back to the store clerk and then turned with the umbrella, or did the umbrella was it visible and apparent as they entered right off the bat? And there's a number of different through the problem, a number of different issues in which the testimony is inconsistent. And so part of what the problem is designed to do is just to get the students working with the question of directed verdicts and whether or not the case needs to proceed forward, or instead whether the judge can issue that directed verdict. And so when I polled the students about that narrow procedural question, given the numerous issues of fact that are baked into the question, they quite rightly, and happily for me as teacher, they quite rightly concluded, no, this is not appropriate for resolution in that fashion. The problem, the difficulty in the problem is that there's also a question baked into it of whether whether it's appropriate for the fact finder to consider an issue of racial identity that is raised by the shop owner, the defendant. So as the problem was originally written, the shop owner testifies that they were aware of a kind of series of small grocery store robberies, including one which had led to an assault against the shopkeeper. And the shopkeeper testifies that they were sort of gang-related robberies. And the customer in the problem, as it was originally written, is described as an African American male plaintiff. And the problem is designed to kind of raise questions about the intersection between self-defense and racial identity from numerous vantage points, from the vantage point of the defense lawyer, the plaintiff's lawyer, the judge, the jury, and you can perceive different questions along the line, like a professional ethics question about whether a defense attorney can offer that testimony consistent with ethical requirements, or if the judge, it's an evidentiary question, does the prejudicial value outweigh the probative value? For the jury, the fact finder, do they consider it, or do they consider it out of bounds? Uh, but the way the problem was written, at least when I came to work with the book, I just felt, was it traded too much on harmful racial stereotypes for it to be, of net value as a teaching tool. I fumbled though in my rewrite because I sort of like unthinkingly or like problematically uh, thought the way to fix it would be to change the kind of the facts to be working with a different racial stereotype. And I wrote it sort of in the wake of 9/11, still very much in the war on terror, a time when there was lots of concern about racial profiling in national security measures, lots of debate about Islamophobia being on the rise in the country and so on. And I rewrote the problem so that the series of robberies and assaults were being perpetrated by an Islamic terrorist organization, and the customer who enters the store was identifiably Arab. Um, and you know, in hindsight, this just was an incredible, you know, mistake not to appreciate how burdensome and harmful that could be to students who were either Muslim or of Arab descent in the class, right? To have to be able to be put in a situation where these issues of identity and animus and threat um, are being, that are very real and very personal for the students themselves, are being treated just as a kind of intellectual exercise in the problem, like like an interesting legal issue. Um, and I give credit to the students who spoke to me about it and shared their concerns. And so the very next time that I've had an opportunity to rewrite the problem, I've rewritten it yet again rather than just jettison it. And I'll explain why in a moment. But the problem, I do think, raises really valuable questions that are worth discussing. And the students often want it to be flatly impermissible. They want it to be flatly against professional ethics rules for a lawyer to use essentially kind of discriminatory or biased presentation evidence. And it's not obvious that that's the case. Here's a professional ethics rule from Massachusetts, which clearly carves out the use of race, sex, national origin, et cetera, if it's at issue in the proceeding, and it's obvious why that needs to be the case. But is racial identity at issue legitimately in the torts proceeding that is being discussed in the problem? We've just gone back full circle to the same dilemma. And it's not necessarily obvious that every judge will always rule that the prejudicial impact of evidence of the sort I'm describing outweighs its probative value, which means that the dilemma for the lawyer about whether or not to use it to, in essence, play to prejudices of the jury remains a real ethical dilemma. What I did in this most recent rewrite is I changed the identity of the customer to someone who wore identifiable garb that's worn by a white supremacy organization. And I had the series of robberies and assaults being perpetrated by that organization. I kind of modeled it on the Proud Boys organization, who have like some distinctive Adidas shirt that they wear during their events. And I did that, in part to kind of try to keep alive the intellectual questions raised by the problem, but also kind of hopefully lower the stakes for the underrepresented students in the room. But it ended up changing the dynamics more than I anticipated. So what I did when I was trying out the problem was I randomly assigned which version of the problem students in the class got. So half the class got the Islamic terrorist organization treatment, and then half got the white supremacy organization treatment. And they didn't know that there were different treatments. And they were organized into small groups of students who served as juries and deliberated about whether or not they would deliver a verdict for the plaintiff or instead would recognize self-defense in the case. And the Islamic terrorist organization treatment resulted in 71% of the jury's finding for the plaintiff, only 29% feeling that the defendant was reasonable in their belief that force was necessary to defend themselves. In the white supremacy organization treatment, on the other hand, only 38% of students thought the plaintiff should recover. So that's a very significant difference in student viewpoints. And the only essential difference in the treatments is the racial identity of the customer. And when I then reveal those results to the students, a very interesting and valuable dialogue kind of opens up. We've now got to reckon as a class with a very explicit racial asymmetry in the students' reactions. One that some might say it kind of opens them up to a reverse discrimination kind of argument. So how do the students explain or account for these differences in reactions? Can they defend them on a kind of an account of historical and continuing racial injustice? Can they account for that, in a context where, tort is very focused on justice between individuals and the kind of the relation of right and responsibility in this dyadic pair of one shopkeeper and one customer. Yet they're bound up with social identities that partake of group responsibilities and group histories and group biases. How do we reconcile those things? The conversation was very successful, much more successful than some of the earlier runs I had with that problem, in part because of shifting the identity of the customer, but also because of running the experiment this way. So the next example I want to talk about is a new case out of California, BB versus County of Los Angeles. This is in some sense an extremely straightforward tort case involving a question about how comparative fault plays out in the apples and oranges context when you've got intentional torts versus negligence on the part of a plaintiff. It was an intentional battery claim based on police excessive use of force. It led to the death of a victim who was Black. And the jury found that the victim was 20% at fault. An intermediate appellate court held that the state's comparative fault statute mandates that the victim's pain and suffering or non-economic damages recovery be reduced by that 20%. The question on appeal is whether that reduction applies even in the case of an intentional tort like battery. And the majority opinion is written by Justice Ming Chin from the Supreme Court of California and treats this as a very straightforward statutory interpretation question. And it's pretty easy based on the existing precedent to conclude that that the intentional tort really should not have the claimant's recovery be reduced by their own negligence. But then a very interesting kind of sub-dialogue opens up within the case because a concurrence is written by two other justices. The majority opinion, in a footnote at the outset of their opinion, sort of responds to the existence of this concurrence by saying, yes, we're aware that the plaintiff in this case was African American, and we're aware that this was police violence, and we're aware that this is a very troubling aspect of our society, both now and for decades before. But this is just a torts question. This is just a statutory interpretation torts question. And that's what they say in the footnote. The concurrence, on the other hand, which is written by Goodwin Liu and joined by Tino Cuellar, both interestingly former law professors, it takes a much more expansive approach. The opinion, both opinions were published on August 10th, 2020, so less than 3 months after the murder of George Floyd. And the concurrence kind of embarks on a pretty remarkable history of racial violence, and in particular kind of legally supported racial violence in our country. I mean, from slavery on to the present day. And it's a pretty remarkable opinion, a hard opinion to read, but it offers an extraordinary opportunity to talk about the role of tort law and the role of judges in a context of broad societal challenges like how do we end racially motivated violence? How do we ensure true substantive racial equality? And what I like about teaching the case is it really offers this opportunity to kind of humanize the judges. So not only in the ways I've already kind of described a couple of the justices, but there's a moment in the concurrence when they're talking about how qualified immunity doctrine has meant that Section 1983 has been such a weak vehicle to combat police misconduct and police racially motivated violence. The concurrence cites a case from the Southern District of Mississippi. And normally we just kind of read over these string cites and don't really focus on them all that much. But in class, I'm able to say, well, why is the California Supreme Court citing a federal district court from the Southern District of Mississippi? And notice the cite is only, 6 days before the concurrence is published. Well, that opinion was written by Judge Carlton Reeves, who's a really remarkable federal district judge in Mississippi. Reeves was a student in the first integrated public school class in Mississippi. As a teenager, he worked a job cleaning the office of the U.S. District Judge at the time, William Barber. Later, he's appointed to replace Judge Barber by President Obama. And in doing so, he becomes only the second African American to serve on the federal judiciary in Mississippi. Carlton Reeves became very well known for a remarkable speech he issued while sentencing three white men to murder in a hate crime. That remarkable speech was, you know, read by millions of people, at least on this website where I saw it had been downloaded millions of times. The case that's cited in the concurrence in BB versus County of Los Angeles is also, it's a striking case. As I mentioned, it's a long opinion kind of bemoaning the state of qualified immunity doctrine and really being extremely critical of it, but ultimately concluding that the officers at issue were entitled to qualified immunity. The opinion's clearly written in a way that's designed to do more than just decide the narrow issue before the judge. This is the first page of the opinion. It begins by talking of Clarence Jameson as the name of the plaintiff in the case. He wasn't jaywalking. That was Michael Brown. He wasn't outside playing with a toy gun. That was Tamir Rice. It goes on and on. The next page lists a whole bunch of other tragic losses. And so clearly, the judge is trying to do something through the vehicle of adjudication that is kind of beyond a narrow understanding, speaking demos prudentially, to use Lonnie Guinier and Gerald Torres's term, speaking to audiences outside of the claimants before them. And I believe that's clearly what the concurrence is doing in the BB versus County of Los Angeles case. And what I do through these examples is use them as an opportunity for the students to discuss and debate. Is this an appropriate and effective use of the judicial power? And what's interesting is the identity of the judges in the case is more complicated than in so many of the cases that we read in torts. So many coming from earlier time periods when the judges were almost exclusively white men. Both the opinions in this case were written by Asian American justices. The only African American justice on the court at the time, Leander Kruger, did not join the concurrence. So specifically did not join the concurrence. And I show this slide with this image of the justices, in part to help, because it shows a dynamic in which we don't have the kind of like normal predictable alliance of conservative judicial opinion written by a white man, and then that creates kind of dynamics within a classroom of alliance or non-alliance, and kind of makes people feel a little bit kind of cabined in what they might be able to say. Here, there's more permission for identity and viewpoint to be kind of less aligned, and it just by virtue of the opinion itself, it shows the possibility of genuine good faith disagreement along a spectrum. In this case, the spectrum of what's the appropriate use of judicial power to kind of call out and speak to larger societal injustices beyond just the confines of the case presented. Okay, so that's the second example. I'm gonna give you one more, and then really invite a conversation with all of you. So this is a recent case from Ohio, and the two examples I just gave were ones where I fairly tightly controlled the classroom setup. This is an example of where things went in very unexpected directions for me. This is a new case on the invasion of privacy tort, and it essentially involves I think there's 4 plaintiffs who were fired from their jobs, either because they refused to take a drug urine test, or because they attempted to take it, but were unable to produce a sample. And the reason they either refused or couldn't produce a sample was that the employer, without notice, switched from their usual sample collection method for drug testing to what they called the direct observer method, where a, a, a manager or a person hired by the company would go with the employees to the bathroom and directly observe them collecting the urine sample. And the plaintiffs argued that this was an intrusion on solitude, that this was a highly offensive kind of invasion of their privacy, and that the employer had not offered any notice about the change in policy, had not really provided any explanation why they decided they needed to go to a level of direct observation rather than just self-sample collection, as had historically been the practice. The majority opinion situates it as a kind of clash between two different normative orders, between tort law on the one hand and contract and employment law on the other. And of course, in the latter, the employment at will doctrine prevails. So the presumption is that people can be fired in Ohio or quit in Ohio for any reason at any time. And so with the employment at will doctrine at play, the majority reasons that the plaintiffs could have been fired regardless. So the fact that they were fired for either refusing or failing to produce a urine sample, doesn't lead to any invasion of privacy cause of action. Um, the dissent, on the other hand, says, look, this is more complicated than that, right? Like the at-will doctrine doesn't mean that an employer can commit any intentional tort against its employees, surely. And hypothetically, you could ask, well, does that mean that an employer can say, you've got to let me punch you in the face, or you've got to let me sexually harass you, or as a condition of employment? Just like this plaintiff is arguing, they said, you have to let us invade your privacy in the bathroom as a condition of employment. Why is invasion of privacy in that sense being treated as a kind of lesser tort subject to being trumped by the employment at will doctrine if we wouldn't do the same thing for battery, for instance? So in class, I asked the students how they thought an invasion of privacy claim along these lines might fare in other social contexts. So for instance, what if a public high school mandated drug tests with direct observers for any students who participated in extracurricular activities? Or what if a private law school started to require drug screening of students, given the sadly high levels of substance abuse that exists among lawyers? Maybe they would want to put in place a preventative plan for law students and require direct observation. Would that give rise to an invasion of privacy claim? Or would there be some countervailing doctrine similar to the employment at will doctrine, which would trump their would-be tort claim? I thought we'd end up having a conversation about kind of different social statuses and different levels of power among individuals in these various settings. And so, which groups in society would be afforded trust and dignity and the benefit of the doubt, and which instead would be subject to surveillance and scrutiny. And what would be the role of tort law in either reinforcing those social dynamics or trying to shift them? That's what I thought would be the conversation. What I didn't anticipate, but probably should have in hindsight, is that the conversation would segue into a conversation about bathroom access rights for transgender students. And a student asked in particular, would a university be vulnerable to an invasion of privacy claim if the university decided to require cisgender students to share bathrooms with trans or non-binary students, assuming there was a cisgender student or group of students who objected? And as is so often the case in tort, the relevant doctrinal test doesn't provide much guidance, right? We would have to ask, would the school's policy be considered highly offensive to a reasonable individual, so that they could, in essence, make out an intrusion of solitude claim? That led to lots of conversation among the students about, you know, what reasonable individual would think that it's highly offensive to be asked to share bathroom space with a transgender student. And that kind of led to lots of conversations about how the kind of the bathroom wars in America at the moment are in some sense a manufactured controversy. It's another one of these culture wars that's being kind of amplified and stoked by forces that, have maybe different motives or are differently situated, um, to the people that we sometimes think are the ones who are, most invested in the culture wars. Um, but some of the arguments, like safety arguments and whatnot, appear to have essentially no empirical basis to support them. So a lot of the students would argue there'd be ample opportunity for a school that adopted an equal access bathroom policy to defend the policy by saying a reasonable person just couldn't deem this to be offensive, because a reasonable person would look at the evidence and see that there are no kind of plausible safety or other, social welfare arguments to defend it. But I didn't let the conversation rest there. I really also wanted it to be an opportunity for us to challenge ourselves to try to see and understand a hypothetical plaintiff's argument, in this case. So could the students get themselves to a position where they could articulate an objecting student's concern over, an equal free access, bathroom policy? Could they see the objecting students as somehow being in a position similar to the objecting workers in the Lunsford case? Um, and if they still wanted the two cases to come out differently, if they wanted the workers to succeed, but not the objecting students, in the transgender bathroom context, can they adequately explain why? Um, Now, given the political makeup of the class of students that I showed earlier, I didn't expect anyone to change their minds. And of course, they pointed out quickly that, the dignitary and equality interests that are at stake, in a bathroom access policy for transgender individuals, that's a very different interest than the largely economic interest of employers, that's being pitted against privacy concerns in the Lunsford case. But my goal wasn't to change anyone's mind, of course, but it was just to make them better lawyers. And despite how turbulent and, the political and cultural climate of our country has become, I still believe we're most effective as lawyers when we take care to understand and address the other side's arguments respectfully. And so that's why I remain committed, to, trying to have our students engage even even with arguments that they find deeply hostile and unsettling, finding a way for them to engage those arguments, um, that still, at the same time is safe and supportive for them. So that's where I end this webinar, still wedged between the rock and the hard place, and eager to hear any questions or comments that you might want to offer. Thank you.
And thank you, Professor Kysar, for your presentation today. Um, Everyone in our audience, I just want to let you know we have now entered the Q&A portion of the webinar. As a reminder, if you would like to ask a question, please type it into the chat and I will read it aloud to our presenter. It looks like we do have a few questions, so let's get started. First question is, I don't know how eager my students are to engage with people with different viewpoints, even if they do acknowledge the benefit. Are there strategies you have found useful to promoting the sharing of different viewpoints in productive ways?
Thank you. So let's see, I think it's 3 years ago now, I um, I kind of radically, altered how I taught torts. And in hindsight, it was a very uncontrolled experiment because I basically changed everything at the same time. So it's very hard to draw definitive conclusions about what was effective and what was not. But instead of the traditional model of, a tiered classroom where I'm at the front and all the students arrayed in rows facing me, and the dialogue is very much back and forth between me and a student and a student. Instead of that, I really tried to follow, best practices for pedagogy that are, being followed in other parts of the campus or in high schools and so on, which is student-centered learning. So I tried to create a very, very different learning environment. I found on campus a flat classroom that was filled not with rows, but with circular tables and movable chairs. And I created learning groups. I broke the 120 students down into like 12 different learning groups. And they were all around circular tables looking at each other face to face for the entire semester. I had each learning group spend the first couple of days of class like negotiating and agreeing to their constitution, like their learning group constitution. What were the principles of engagement? How would they manage time? How would they share space? How would they handle conflicts? All this sort of stuff. Throughout the semester, I often had students doing the presentation of materials. The groups would present portions of the class. We did lots and lots of role plays. We would do, when we had conversations, they wouldn't be classroom wide. They'd be at the small tables. Um, there would be, I tried fishbowl techniques, which are interesting. It's where like one group would be doing a role play, like say that very difficult self-defense problem involving racial prejudice. One group would be debating it, and another group would just be sitting around watching them and like observing their interactions. And then afterwards, the observing group would kind of say, "Oh, I noticed somebody's body language changed when you said that," or like, and that fishbowl actually turned out to be extremely useful. I had students for part of that semester, instead of when I'd pose a very difficult or hard question, instead of like cold calling or having people share, I had them journal. They kept on their laptops, they kept one document, which was their torts journal, all semester, where they could reflect quietly and privately about difficult material that we were working with. So basically, I just tried to change everything. And like I said, in hindsight, I don't know that that was a great approach to try to figure out what worked and what didn't work. But I can tell you that those students in that class, they definitely, had a deeper level of engagement with one another than I would experience in my typical, traditional Socratic classroom. And so maybe trying one or more of any of those techniques out would be useful. I'll end with one final example, which actually comes to me from my property teacher when I was back in law school, Duncan Kennedy. And Duncan Kennedy would often say what he's trying to do when he puts a question out there is he's trying to generate a spread within the class, not just like a yes or no binary, but a spread of viewpoints. And like in torts, when it comes to emotional distress recovery, you could imagine like a group that says that it shouldn't be recovered at all under tort, or it should be like the strict thing versus lechuza requirements, or it should be the flexible Dillon versus Legg requirements, or it should be much more open-ended. Emotional recovery should just be as expansive as physical injury recovery. Like you use the polling software to try to align people on that spectrum, and if you get a good spread, then it makes it more comfortable for there to be back and forth and debate and kind of mutual exchange than if it's just this kind of binary all or nothing, you're with us or you're not with us. Hope that's provides some useful thoughts.
Yeah, no, thank you. It sounds like you put your students in a lot of different, gave them a new experience for the classes, and I think that's great. It sounds like they really got a lot out of it. Um, you mentioned polling, and I have a question here. The polling questions and responses you shared are interesting. Have you conducted these over multiple years teaching torts? And if so, um, this person's curious if you've seen any shifts in terms of the results.
So I've only used the polling software for like, I would say the last 3 or 4 years in torts. So that's not really enough to see or identify any clear shifts or trends. Um, and, it's not scientific. It's really not designed to be at the level of a social science experiment. It's really designed to be a learning aid. What I do find is that, um, you know, students have different comfort levels with different forms of engagement. And there are some students who are perfectly willing to throw their hand up and say all sorts of, provocative things. And then there are other students who are more reticent, and that by using the polling, it's another way for me to allow those students to try to contribute to the class discussion. I didn't show any of the examples in this presentation today, but there's also open-ended questions where students can type their own thoughts in, and then they can upvote or downvote people's responses, and you can have that set to be anonymous. And so you might end up with a much different kind of conversation enabled through that technology than if you were requiring people to kind of put themselves out there personally and identifiably behind a particular argument or viewpoint.
No, I think that makes a lot of sense. Thank you. I just want to remind our audience, if you would like to ask a question, just type it into the chat to the right of your screen, and I will read it aloud. I'd also like to let our audience know at this time that I will keep the platform open for 5 to 10 minutes after the webinar has ended. So if you do have any questions that you want to ask at that time, you can type them in, and we will send them over to our presenter and get back to you within 24 hours. I do have one more question here in the Q&A. This person says, I really like the cases you shared. What are some others you plan to introduce next time you teach torts?
Great, thanks, Neil. I actually just pulled up the list of attendees, which I had neglected to do earlier. And I know so many of these people. I'm tempted to start cold calling. No, I'm not gonna do that. Um, but but please, anyone who wants to ask me anything, you've got me on the hot spot here. Feel free to throw it in the chat. Um, you know, uh, I'm always ambivalent about new cases because, especially I've been teaching towards 21 years now. So you have your old favorites and the chestnuts, and you really love them. On the other hand, like I have realized that at least the students I'm experiencing in recent years, they're very eager for like the now. Like they're very eager for, they want to learn the foundations and understand the history and trajectory, but they want to be like kind of at the cutting edge. And so I have been trying in the book to kind of put in material that's really right there at the cutting edge, not save it for an advanced torts class, but have it as part of the foundational materials. Um, One of the cases I'm really excited to teach, well, I actually used it last fall. I always try to road test the cases before I put them in the book, is a new economic loss rule case, again, out of the California Supreme Court, called the Southern California gas leak cases. This is a wonderful teaching vehicle. It's an opinion written by Tino Cuellar, and I'm very sad that we've lost him from the bench. He's moved on to head a prestigious foundation because he was making a mark as like a great torts jurist. I mean, he was up there with Roger Traynor and so I'm sad to see him leaving the bench. This case does a wonderful job of synthesizing a very complex, murky, contested area of law, and kind of drives the final stake in the coffin of a couple of cases that I had loved teaching. The People Express case from New Jersey, and the Jair case from California. Love teaching those cases, but sadly, when I read Southern California Gas Leak, I just thought, I can't do this anymore. It's no longer like kind of appropriate pedagogically to be teaching these two cases as if they're highly influential and important. And the Southern California opinion does a great job of kind of showing why they didn't end up having the kind of impact that casebook authors and scholars might have thought once they would have. I also like teaching the case, though, because Justice Cuellar gets into a lot of law and economics reasoning in the opinion, some of which is is arguable, and I love kind of challenging the students to take on the judge, especially given that many of them have economics training from undergrad or even from graduate school. Um, that's something I'm really excited to start including in the mix. I put in a couple new cases in the kind of First Amendment torts intersection context. So there's a case called Gilmore versus Jones, which is a defamation case brought by one of the counter protesters who was in Charlottesville during the Unite the Right rally that turned deadly violent. And he's actually the person who filmed the driver crashing into the crowd of counter protesters. And that person was subjected to a kind of like a conspiracy theory smear campaign by some online and broadcast commentators. They're saying he was like a deep operative of the liberal state, and the opinion is a kind of pretty methodical effort to march through defamation requirements, which, as everyone knows, are extremely challenging for plaintiffs to meet, at least in our country. But this is one of those rare cases where the case makes it past summary judgment. So it's valuable for that reason. The other case is called Rich versus Fox News Network. It's written by Guido Calabresi, Second Circuit case. It involves an emotional distress claim by the family of Seth Rich, who was the staffer for the Democratic National Committee who was murdered. And then his murder was kind of turned into, again, a kind of conspiracy theory, viral media attack in which he was claimed to have been responsible for the WikiLeaks, and that he was murdered in retaliation for WikiLeaks. And the opinion's quite powerful in trying to disentangle the protected media speech from the conduct, which could instead be construed as infliction of emotional distress. What I like about those two cases is that they're very now, they're very much focused on how does tort interact not only with the First Amendment, but also with the kind of public forums that we have now, which are problematic to say the least. I find that those are really exciting vehicles to teach with.
Okay, thank you. And we do have quite a few more questions that have come in, so I'm going to get right to those. The first question is, how, if at all, do you incorporate humor into your classroom, given the gravity of the material and the concerns we're talking about here?
Hi, Anthony. Thanks for your question. And I hope I didn't guilt everybody into offering these questions. So I think it's really tricky because I feel like as torts folks, we're reading hundreds of torts cases a year, and they almost all involve real tragedy, real misfortune, real suffering, and you can almost become numb to it and develop a kind of gallows humor style in talking about torts cases. And I try to be very self-conscious in resisting that, be, particularly because of that electrocution anecdote I told at the outset of the hour. Like that really that shook me because I was very early in teaching when that happened. But it, I do. I mean, I do try to use humor. If any of you have seen my slides and they're available through Aspen, if you're interested, there's a lot of kind of humorous digressions in there, but I try not to have them, focused on the the serious and the hurtful aspects of the material. I try to find, places that are safe for using humor. Um, Other things I do, like I teach here in Yale, and people have often said that, people come to Yale despite New Haven. Well, I'm a big New Haven fan. I love New Haven. So like I spend time in class. I'll devote 5 minutes a couple times a week to talking about New Haven and things that I love about my community that have nothing to do with Yale, trying to kind of get the students to think outside of law school, outside of this building, and just kind of keep them aware that they are three-dimensional human beings and not just law students. Because I remember what it was like to be a law student. It's so easy to just become all consumed by this process of learning immersion. Um, but you got to keep your groundings. So I'm often doing things like that, or even like, you know, mental health and self-care public service announcements unexpectedly. And I find that is often appreciated by the students. Like sometimes they need permission to do what they know is best for them.
Well, as someone who grew up in Connecticut, I can say there's definitely nothing wrong with New Haven.
Thanks, Neil.
Another question. Rebecca says she's already borrowed so much of your pedagogy. Curious what topics you cut to make room for your new classroom exercises, and which do you miss or not miss?
That's a great question. Thanks, Rebecca, and hope you're doing well. A couple of years ago, my law school voted to kind of rebrand torts as a new course called Torts and Regulation. And we're supposed to be teaching torts kind of in conjunction with an introduction to the regulatory state and agency methods of dealing with issues like drug safety or worker safety and so on. Um, I haven't gone full bore to like a 50-50 torts regulation treatment like some of my colleagues. I remain kind of a torts romantic, but I've had to put in a couple of weeks in which I talk about, agency approaches to safety decision making and how they relate to and contrast with torts. And that required me to jettison a lot of my traditional material, um, including like I had to shrink products liability way down, and that hurts me because I love teaching and talking about products liability. Sometimes I've had to cut trespass and nuisance entirely. Again, that hurts me. I mean, I when I started at Cornell, torts was still a 5 credit class, and now it's down to 4 units, 3 units in some places. Um, it's now I'm gonna start needing to break out the tissues here when I think about it.
Okay, thank you. I'm going to go right into the next question from Kevin. When you use a new case in class, do you edit it in advance or do you have students read the full case?
Ooh, it's a great question. I edit in advance, but I'll say one of my other great torts mentors, John Hanson, who was my torts teacher in law school, he moved in his career to teaching unedited cases, because he felt like that's part of being a lawyer, is like learning how to digest massive amounts of material and to kind of be able to zero in on what's the really important stuff and what's extraneous. But I've always edited them first, partly because I have this kind of unverified hypothesis that there's a tipping point where if I assign too much reading, then the students will read 0%. It's not that they'll adjust down to keep it at a tolerable level, it's that they'll boycott. So I try to keep things very manageable.
Okay, and Nicole asks, she agrees she likes the new cases. She's also curious how much you use these principles with older cases, especially ones that do not actually mention race, but in which race was likely an issue in the practical sense. She gives examples: Woodward v. Uh, Turnipseed and possibly Shorter v. Drury.
Thank you for that question. It's a great one. And I'd really recommend looking up some of the scholarship and work by Professor Riggins at University of Maine. She's really done a wonderful job of like excavating the social and often racially inflected context of some of the older torts cases that people teach. And she's very generous in having teaching materials posted online that can really help in doing that. I often, anytime we can find, you know, scholarly work that has done legal history and kind of law and sociology analysis of the larger picture of cases, I try to draw on that and use it in class or even put it in the book if I'm able. And it's often like incredibly enriching. So um, there's that interesting false imprisonment case of the person who was kept on a quote palatial yacht um, that was owned by a religious cult from Maine. The opinion itself doesn't really get into all the very interesting background. And there's a article published by a University of Maine law scholar. It's like a 100-page article on the whole background of that case, which is extremely fascinating. And there's a lot of articles out there that have done that for some of the very prominent older cases, and it definitely enriches the conversation a lot.
Okay, thank you for that, for your insight. Professor Kysar, I do not have any other questions in the Q&A at this time. So I just wanted to hand it back over to you, just if you have any final remarks, and again, say thank you for your presentation today.
Well, thanks to everybody who joined. And, we're a community, and I, am always eager to hear from people who are teaching torts and, would love to compare notes and strategies. I'm always trying to be a better teacher. And so please, if you know of things that you've found to be particularly helpful or useful and are willing to share them with me, I'd love to be in contact with you. Thank you.
Okay, thank you again. And today's webinar has now ended. So thank you to our audience for attending, and we hope you have a great rest of the day.